3-203.14 sub 2, Tyler James Robinson intentionally selected Charlie Kirk because of Tyler James Robinson's belief or perception regarding Charlie Kirk's political expression. And so, if that was not here, this enhancement, and it also goes to count 2, felony discharge of a firearm causing serious bodily injury. And I'm just reviewing. And then finally, count 7, violent offense committed in the presence of a child, where the victim targeting enhancement also is in play. Because that is part of the information that's squarely before the court, this becomes relevant. Now, trying to determine what is political expression versus religious expression, that goes into different grounds, but at this point, the court finds it is relevant for consideration, and for the very least for argument. What the court is going to rule is that the need for a closed hearing is not been met at this point, because what needs to be shown is prejudice, or that the exhibit contains inflammatory information that would prejudice the jury pool. That begins the path where we can consider closing the hearing from the public. However, that's not what's before the court, nor has the court heard that. And so the ruling of the court is, previously I sustained Mr. Novak's objection, and the court will expound upon that Mr. McBride in his argument cannot read the entirety of State's Exhibit 5.1. Can he reference points of it and specifically quote certain points? The court rules that he can, just as Mr. Novak pulled from this, and it was broad, but he quoted Matthew chapter 19. He stated that this came from the Bible. He talked about the going from paragraph 1 where he quoted, or at least drew from, about the Internal Revenue Service and the type of business. And so there is grounds for that to occur in order for the court to consider the argument fully and making the determination whether it is relevant and should be admissible. Therefore, the court rules that Mr. McBride can continue in his arguments in order that the court can make its determination whether State's Exhibit 5.1 is admissible or not.
Thank you. 5.1 is a general explanation of what Turning Point USA, Charlie Kirk's organization, is and was on September 10th. The exhibit describes the events that Turning Point USA holds, talking about at least 200 plus of these events featuring Charlie Kirk as a headline speaker had taken place by that time. That's in paragraph 3. That these events discussed political issues as well as religious issues. Those political issues in the portion I previously quoted talked about gender issues in particular, gender, sexuality issues, the difference, or the Christian and political view regarding marriage and families and gender identity. And that information is relevant to the motive that we are alleging in this case. And it's also relevant to the victim targeting enhancement, which is in part a motive type enhancement. And the evidence will be introduced through, or we will offer evidence through other witnesses that talks about some of the defendant's statements that indicate his gender persuasion, and that he falls into some of these political and gender views that Charlie Kirk argued against. That's the relevance of this statement, is it shows Charlie Kirk publicly in front of large gatherings of people debated and presented his views, his political views, which were tied to his religious views about gender identity, LGBTQ rights type issues. And the relevance to that is the defendant's motive is that he was on the other side of those views. And you'll see evidence that talks about that through other witnesses. That talks about that being the inference and the motive that he had, or the inference from that evidence supports that motive, which supports the victim targeting enhancement, and frankly, motive in general, which goes to identity. For that reason, Your Honor, this exhibit is relevant. I don't see the prejudicial effect, unfair prejudicial effect this would have on the fact finder. Whether or not it has, some capability of prejudicing the potential jury pool, I think that's a completely different question. I don't think it does. I think this case has already highlighted the political issues that we're talking about here, but my job here is to present this case to the court, to you, Your Honor, for you to make a decision. This evidence is admissible for that purpose. Whether or not it's public or published for the public to see is a different question, which I'll submit. The media is very capably represented, and I'll let them make the argument on that point. But I would ask the court to admit this exhibit.
Mr. Novak.
Thank you, Your Honor. For the state to argue that this exhibit says anything about Mr. Robinson's state of mind should be rejected out of hand. This exhibit does not say anything about Mr. Robinson's state of mind, and that's what motive is, and that's what the victim targeting enhancement adopted by the legislature focuses on, is the defendant's perception. If Mr. McBride wants to propose significant redactions to this exhibit so that Your Honor, acting as a magistrate, can consider things that are narrowly tailored to what the information alleges, which is the allegation is that Mr. Robinson perceived that Mr. Kirk had certain political views, that's one thing. But this document talks, and now Mr. McBride, not to be colloquial, has sort of thrown down the gauntlet. This document talks about foreign affairs, political doctrines, America's founding principles, cultural trends, and what Mr. Engelhardt refers to as Orthodox Christian views on sexuality, marriage, and gender/sex. So this document goes way beyond what the state just flagged for the entire world is their view of Mr. Robinson's motive, which has something to do with gender identity, gender ideology, and sexuality. That's what Mr. McBride has just said this case is all about. This document goes way beyond that, and that's why it's not admissible. There may, as I said, be other evidence which Mr. McBride and the state want to rely upon, which they haven't presented yet, and Mr. McBride hinted at that. So I think that it's not admissible at this point in time. I don't think